Hi, I'm Shan Wu with a Under Color of Law hot take on enforcement, meaning enforcement via contempt proceedings. So I've been thinking a lot about exactly the big controversy over how will courts actually enforce any rulings against the Trump administration. This has really come to the forefront recently with the headlines about J.D. Vance's statement in which he suggested that the courts don't have the power to assert any authority over legitimate decisions by the executive. His statement is causing a lot of hyperbole, right? That's the emphasis on legitimate. That's Vance's trickery. As we've discussed before, he gets to play to the public by trying to claim the courts would be doing something wrong for saying that Trump's actions are illegal, while completely ignoring the fact that that's exactly the court's job, is to decide the legality of the issue. And notice that's not really what's happening, right? We're not at that stage yet. Some courts have issued TROs, there are lawsuits going on, and we're not at the point where the administration has actually said, we've decided this is a wrongful court ruling, we're not going to cooperate, which brings us to the constitutional crisis hyperbole. And I'll explain why I think it's kind of hyperbole and why, in some ways, that's a bit of a distraction. Let's take a listen to my colleague Elie Honig on CNN discussing this matter.
Going back to 1803, in the famous case of Marbury versus Madison, the Supreme Court said that it's the courts that ultimately decide, that have the last word on what is constitutional and what not. It's not up to the executive, it's not up to Congress, it's up to the court.
Which is not what J.D. Vance is saying.
Which is exactly what he is not saying, which is saying that, you know, the risk here is that the executive can just do what he wants without regard to the Constitution, and that is a situation we've never been in.
Now, Elie goes on, I cut him off, to explain about the unitary executive theory, which is basically this notion that the executive has ultimate power over everything in the executive branch. That doesn't really address the real life enforcement question, which comes down to the use of contempt by federal courts against the government. I myself made a mistake the other day on CNN, it's kind of early in the morning, when I said there had been previous contempt findings against agencies as though they were commonplace and fines could pile up. We had a discussion about who would pay the fines, really would be taxpayer money, obviously. But I was wrong about this, which was, I was thinking of a notorious case about mismanagement of tribal funds by the federal government, the BIA, that was litigated during the Clinton era, and where a DC judge, very legendary judge, Judge Royce Lamberth, really great judge, held not one but two secretaries of the Interior in contempt of court during this litigation. But in reviewing some of that history, I realized that actually no fines had been imposed, and in fact the question over what the contempt process is runs much deeper than that. But it's interesting that I made that mistake, because it gives, well, taught me the impression that most people have, that certain things have happened when actually they haven't. So let's just drill down on that a little bit. First, let's dispense a little bit with this constitutional crisis, separation of powers argument, because it's a little too superficial. Yeah, we have a separation of powers, we all get that. But that does not address who wins in a showdown. So, for example, the crisis scenarios, courts say that the executive is doing something wrong, or Congress is doing something wrong. Let's do Congress first. Congress refuses to correct this wrong. And how would you enforce that? After all, Congress could, theoretically, with the power of the purse, just defund the courts, right? Okay. Next. President's orders are found to be illegal, unconstitutional. He did not follow the Administrative Procedures Act, for example. OMB refuses to rescind an executive order. What happens? Do we jail the head of OMB who defies the court finding? The crisis scenario, U.S. Marshal Service would refuse to follow the orders because they answer to Trump via DOJ. Well, theoretically, I would argue that that's not actually a constitutional crisis if that happened, because there's zero playbook for how to resolve that. That's simply an outright rebellion on the part of the executive. They won't answer to the courts. The reason I don't like the term constitutional crisis is it sounds as though there is a crisis looming versus we're already in a crisis, and what will be done about it. So it's more important to focus on what's actually happening, what can be done against these illegal programs, how to show that they're illegal, how to get Congress to take action, than it is just to talk about whether there's an impending constitutional crisis or even whether we're in one. It's not, and that's because it's not like saying it's a constitutional crisis means you pull like the special alarm bell, 5-alarm fire, 7-alarm fire, take your pick. It doesn't do anything because it's the whole question of who is responding to the alarm. So actually, scholars who've looked at this question don't give us a very clear answer about what is the enforcement power, and it's basically a contempt power if the agencies are in the wrong here. The real foundational work here was done in a study law review article by Professor Nicholas Perlow, and it's summarized here at Just Security by Professor Perlow himself. His findings indicate, and they're pretty extensive in the actual law review article, I'll try and keep them very succinct. His findings indicate that trial judges are very reluctant to impose contempt against executive agencies or the executive branch. There are no cases of fines at all accumulating, and appellate courts have bent over backwards to duck the issue of whether the contempt is enforceable. And the Supreme Court has never directly addressed the issue at all. Why? Because the normal sequence of events, as Brill concludes, means that the threat of contempt and kind of the shaming, that sounds a little bit schoolyardish, but the shame aspect usually compels some degree of cooperation from the agencies. And the matters are very complicated, a lot of the agency discretion issues, a lot of complex regulations, and it really takes the shape of a very long negotiation with the agency, which, in my opinion, is why Musk and Trump were in such a hurry. They don't want changes taking years through litigation, figuring things out. They want the power right now. So let's keep the focus on some practicalities. If an agency were to be fined for every day you keep in place the blank executive order, going to fine the agency X amount of money, well, it would really ultimately come out of taxpayer dollars, right? It comes from a different part of the budget, from the agency's, different part of the agency's budget. And notice Musk wants to get access to the payment system at Treasury, right? That could be very helpful with that. Fines against an individual official could also be reimbursed to that individual. Jail for an official has basically never happened. The shaming aspect appears to be ineffectual against higher-ups because Trump, Vance, others don't really care about the shame aspect, right? Musk obviously doesn't care about that at all. But it's important to know it is going to worry the lower echelon people. They're going to care about the shaming aspect. They're going to worry that maybe they could be in trouble, maybe put in jail versus any of these higher-ups. That won't happen. And maybe that's also why Musk and Trump want to get rid of as many lower echelon federal employees as possible in a hurry. They're trying to eliminate hundreds of thousands. They set a buyout offer to 2 million of them. So that issue the professor addresses when he recounts that when Lamberth was overseeing this litigation and held in contempt not one but 2 Interior Secretaries, that it had a really tough effect on morale of the actual employees at the Department of Interior. Lamberth was very vehement about this, at one point referred to the Interior Department's actions as being racist, even. Now, eventually, DOJ succeeded at getting Lamberth removed from that case. Now, don't think that's not also in the playbook for Trump's DOJ. No, it wasn't by impeachment, but it was by mandamus. The appellate court basically felt that he was like so vehement that his objectivity was kind of questioned, so they replaced him and put in a different trial judge. Now, this is why, actually, the lawsuits are effective. That takes time. And that time could force the Trump regime to take a stance to defy courts, which would give the Dems a lot of hay for the midterms if that sort of rebellion point was actually reached. It's not highly unlikely that it has to reach the point where he does what looks like a military takeover, right? He orders the Marshal Service to occupy some building, orders the military in, because he doesn't really have to do that. That's what's becoming clear here. It's not that we shouldn't have court battles. We'll talk about that in one moment. But even as the courts rule against him, even as they may impose some TROs, his technique of using Musk, creating this deliberate black box, means there can be a lot of ongoing hidden harm being done. Even if they say, okay, we'll comply with that TRO. One of the TROs, I think the conditions was any copies of computer code, documents, etc. from Treasury had to be turned in, right? Hard to enforce that when you actually don't know who's got it. First question is, let's identify all the people who have it. And you got to question, do you trust that or not? But there is a process going on. And also congressional hearings would be really important to help shed light on this, as well as whistleblowers. The point is to approach this from many, many different directions. Lawsuits to slow it down, try to get rulings that the Trump administration has to figure out what position to take on those rulings, have whistleblowers emerging, have congressional oversight hearings, and put a lot of pressure on the members of Congress. These phone calls being made to them, they have an effect. There have been millions of calls that have come in. That is overwhelming them. They're going to listen to that. There's even an app for that, which will put that up, that story. I hadn't heard of that app before. So that's really the bottom line here. The legal concept of the enforcement, somewhat blurry. Why? Because the norms have been in place and have never gotten to the point where someone wants to just completely defy the norms. Lastly, we're not quite there yet. Vance is trying to play to that political audience. They haven't gotten to the point yet because they don't have to. We want to push them to that point as quickly as possible, bring sunlight onto the whole process. So that's it for now. We'll continue to keep an eye on this because there's a lot of enforcement issues that are going to be coming up. Thank you for the replies and comments. That was one of the reasons I chose this topic. A lot of folks are asking about the mechanism, and we will talk to you soon. Oh, do follow me on Blue Sky. We're trying to keep up with so much of the stories that are coming out, so follow me there and we'll give it a little bit of a deeper treatment here. Thanks.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.